The first case before us is State of Ohio versus Alma. In this case, we just have the appellee making an argument. The appellant has waived. You will have 15 minutes to present your arguments. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument, and you can refer to them by initials or terms like the child. We've read your briefs and are ready to proceed.
Thank you, Your Honors. May it please the court, my name is Brian Smith on behalf of the appellant Alma. Your Honors, there were two assignments of error raised in this case. They're somewhat interrelated. They both concern the denial of the petition for post-conviction relief. First of all, the findings of fact in this case were not supported by competent, credible evidence. There was actually very limited findings of fact and conclusions of law here. And if anything, that underscores the abuse of discretion in this case. In most of this case really comes down to a battle of the affidavits, because there were competing affidavits that were presented. One was from the appellant, the other was from Jenny Schucke, the supervising attorney in the prosecutor's office. The lack of the fact finding means that the trial court did not properly weigh the statements that were made in these affidavits. The attorney Schucke was the supervisor for the prosecutor who directly handled the case. She did not have firsthand knowledge of all the plea negotiations that were taking place, even though she would have been the supervisor. And the appellant's affidavit in this case was credible because she would have needed expert testimony to establish the affirmative defense of insanity. She had already gotten 2 prior mental health evaluations. Essentially, the expert testimony is what would have been needed in order to establish this defense had the case gone to trial. If she had been contacted by her attorney and her attorney says, well, we're not going to have this expert available, we go to trial soon, that lends credibility because she doesn't have any other essentially expert testimony or evidence to hang her hat on at trial as far as establishing the affirmative defense of insanity. Now, the state brought up a good point that the stated plea offer was for 1 year in prison. Now, she was charged with a second-degree felony in this case, so a 1-year sentence couldn't happen by statute. However, counsel should...
Excuse me, counsel, but my understanding is the state's denying any of that.
Correct, yes. Their contention was that there was no such offer made, that this was their affidavit contradicted what was in the appellant's affidavit. I should clarify, I'm referring to the appellant's affidavit that there was an offer to plead and receive a sentence of 1 year in prison. And even though the 1 year in prison was a legal impossibility under a second-degree felony, trial counsel should have known that, and should have known, and at the very least it underscores that there's a communication issue, because if she believed that the offer was for 1 year in prison, then it's up to trial counsel to say, well, now your sentencing range on a second-degree felony is 2 to 8 years, not 1 year. Perhaps there was some miscommunication, perhaps there was some misunderstanding as to whether that would constitute time served. But the bottom line is that she didn't understand the plea offer, and that goes to the ineffectiveness of trial counsel at that point. It underscores that trial counsel was ineffective here for not clearly conveying the plea offer to the appellant. And the state also made the point that that we don't have the opinion of this mental health or psychological expert that appellant contends would have been testifying in trial, but this also shows prejudice because she already had 2 prior evaluations. The came back that did not establish the affirmative defense, so.
Is it 2 prior evaluations for NGRI or a competency in an NGRI?
I believe the 2 prior evaluations were for competency. But at that point, if they're finding her, even if they're finding her competent as opposed to evaluating for NGRI, she's still going to need the expert opinion to establish NGRI.
So she was evaluated once for NGRI? I couldn't get that from the brief.
I believe it was once for competency and once for NGRI. I'd have to double check that, so please take that with a grain of salt, but I believe it was one of each. But this shows prejudice because she would have needed this evaluation at trial. And if she doesn't have that, particularly when it's so close to the trial date, this changes the outcome because essentially she received some kind of plea offer, she rejected it thinking, I'm going to go to trial, I'm going to raise the insanity defense, only to find out that this defense isn't there. So, because of the absence of the expert. And if the expert is absent, why isn't the trial attorney filing for a continuance or making some effort to perhaps get this trial continued, line up another expert? So the fact that this expert witness was unavailable such a short time before trial, essentially pigeonholing her into taking this plea, means that she was prejudiced because of her trial counsel's ineffectiveness.
Was the Rule 11 plea colloquy transcript pages provided to this court?
I believe it was part of the prior appeal. I'd have to check and see if we may need to.
So you're not saying that she said anything, that the appellant said anything at the plea colloquy about any of this?
No, unfortunately, none of this came up at the plea hearing.
Okay.
So
The other question I have for you is, I've been around long enough that I remember the old rule had to be findings of fact and conclusions of law, and if there weren't findings of fact and conclusions of law, then it was not a final appealable order. And the rationale for that was so the appellate court could actually see the thought processes and evaluate what the trial court was doing. Now that's not the rule anymore. Are you saying that there were no findings of fact and that constitutes error?
there was no section saying findings of fact and conclusions of law. The order was very short. It was about 1 paragraph, and it said essentially there were no sufficient operative facts to establish relief. So whether this
But the court didn't, I'm sorry to interrupt you, but the court didn't get into what those facts were, right?
No, it was a very cursory explanation of
Yeah.
overruling
I'm
the
just
decision.
wondering because
Or
I'm trying
overruling.
to understand, if you don't really do findings of fact, which I'm not sure the trial court did here, what does that mean? I think the case law says it can be error.
Well, we would submit that it would be an abuse, it highlights that it was an abuse of discretion to deny the petition because the trial court did not make sufficient findings of fact and conclusions of law. Because of this, essentially this 1-page decision that says there aren't sufficient operative facts without really going into detail as to what those sufficient operative facts may or may not have been, that this underscores the error on the part of the trial court in overruling the petition. So we would ask for reversal, but alternatively, if the court wants to send this back and ask the trial court to issue findings of fact and conclusions of law, and we can take this up, and then at that point we can come back here and possibly revisit this, but essentially we would be asking the court to reverse the decision overruling the petition, send this back for an evidentiary hearing on the original petition for post-conviction relief. And I think that's pretty much what I have. I'd be happy to take any further questions with my remaining time.
Any questions?
Thank you, Your Honor.
Thank you for your presentation. This court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail you a copy of the decision the day it's released. The opinions are also posted on the Ohio Supreme Court website. Thank you.
All right, thank you, Your Honor.